And that even included the conduct of setting up a cage in court in which Mr. Zulfiqar Ali Bhutto was made to sit in a cage. And Supreme Court found nothing wrong with it.
ये कहाँ है?
So ये judgment के अंदर ही इन्हीं paragraphs में ये सारा
Lahore High Court.
Lahore High Court में जी.
Was that factually so?
It was factually so. It was taken as a ground in a,
No. Did he sit in? Was
he was made to sit और justify ये किया गया कि so that
it happened, or just we are talking language here?
no, they set up, they brought in a cage-like box in which he was made to sit, and justification was given that he is to be protected.
By
Protected
whom?
from and by whom? And then they said because this was the first time a trial was conducted by High Court and there was no dock, so that's why we have set up this cage.
किधर है जिक्र?
So ये judgment में
जजमेंट
Supreme
में
Court.
दिखाएंगे आप हमें जजमेंट में ये केज का जिक्र कहाँ
तो
पे?
ये इनफैक्ट मैंने ये जो मार्क किए हैं पैराग्राफ्स 841 onwards, each para is
नहीं हमें हाई कोर्ट का पहले दिखाएं. कहीं लिखा है हाई कोर्ट के जजमेंट में केस का जिक्र?
सुप्रीम कोर्ट ने इंडेक्स बनाया उसमें ये लिखा है.
चलें बताएं.
ये सर पेज 53 से शुरू होता है जजमेंट.
ये केज वाली बात जरा बताएं.
जी सर उसमें सीएमए में थी पैराग्राफ 874.
जी पढ़ दें.
In the courtroom in the High Court in which this trial was held, there was no dock, and it was therefore installed before the commencement of the trial. According to the appellant, this dock was specially devised to cage, humiliate, and devalue him in public eye. This may be an unfortunate impression formed by him in the circumstances, but otherwise the necessity for segregating the accused was genuine and apparent from the fact that very great interest had been shown by the public in this case. It is therefore difficult to doubt the bona fides of the court in installing the dock in question. Similarly, there appears to be some room for misunderstanding concerning the remarks about the benches against which the appellant was aggrieved. The allegation that as a result of the seating arrangement in the dock, the appellant and his learned counsel were handicapped in communicating with each other in the court for the purpose of this case is not borne on from the record. It does not appear that any complaint to that effect was at any time brought to the notice of the court, or any application was at all moved in court to draw its attention towards any such difficulty experienced by the appellant in the course of the trial. Before us, neither the other accused nor any of their learned counsel supported the appellant in this complaint, nor did they ever make any such grievance in the court. In the course of the trial on 1/1/77, this is a different ground that the Lahore High Court Chief Justice had become the election commissioner, and he had made personal remarks about the misconduct of the accused in elections.
All accused were sitting in one cage, or only Mr. Bhutto?
Perhaps only Mr. Zulfiqar Ali Bhutto.
What about the other accused persons? They were sitting where?
It doesn't. They didn't. They didn't require security, maybe.
Because ordinarily the High Court does not conduct trials. Now, that may be a reason, because ordinarily in a trial court, the accused sits somewhat separately. I don't know. That could be the reason.
But this, along with the manner in which the appellant, in that case, Mr. Zulfiqar Ali Bhutto, was treated, there is an exchange between the then Chief Justice of Lahore High Court and Mr. Zulfiqar Ali Bhutto. It's all again narrated in these paragraphs. There was so much vitriol, there was so much heated exchange between them personally, and the reason, rightly or wrongly, was that perhaps the Chief Justice of Lahore High Court was bypassed.